there. Honorable, the judges of the United States Court of Appeals for the Fourth Circuit. Oyez, 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 all persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
Good morning, everybody. Please be seated. Welcome to this session of the United States Court of Appeals for the Fourth Circuit. On behalf of the court, I want to thank Dean Martin and the Kenneth F. Kahn School of Law here at High Point University for hosting us this morning in this wonderful space. Dean, you've been nothing but gracious to us. Really enjoyed spending time with you and the students and others at the reception last night, and look forward to 3 really interesting arguments today, and appreciate all who have taken time to be here with us. And so with that, we'll get started. We have 3 cases on for argument. First up is 25-4234, United States versus Moses. Ms. Hester.
Morning, and may it please the court. Ann Hester, representing Johnny Moses. This case spotlights a phenomenon that has become all too common in recent months. Law enforcement officers violated a person's Fourth Amendment rights and then revised history to conceal it. But video recordings reveal what really happened during the encounter. Here, the district court clearly erred when it accepted Officer Mullis's testimony that he saw Johnny Moses run a red light and smelled marijuana, when video evidence contradicts that testimony in multiple ways. Now, Officer Mullis was allowed to stop Johnny Moses based on the registered owner's suspended license. But Mullis violated Mr. Moses' Fourth Amendment rights when he continued to stop after he realized he had stopped the wrong person and without reasonable suspicion that Mr. Moses himself was breaking the law.
But did he initially clearly have the authority to initiate the traffic stop based upon the suspicion of the suspended license?
That's correct. And we don't contest that at all. That's what Kansas versus Glover says. But the problem occurred when he walked up to the car and immediately recognized he'd had a picture of Mr. Moses' father, who was the registered owner, that he'd reviewed beforehand. And he immediately recognized when he walked up to the car that Mr. Moses was not the registered owner of the car.
But he also, at least according to him, immediately recognized or discerned the smell of marijuana.
That's what he testified to, Your Honor. But body cam videos contradict that testimony, both about a red light violation and about marijuana smell in multiple ways that make the district court's fact findings implausible.
Well, but let's start with the fact that there was, in fact, marijuana in the car, right? So that seems to suggest that when he testified to that fact in front of the district court, that there was something to that.
Except for the fact that the marijuana was double packaged in a vacuum sealed bag. And
he had an answer for that. He said that there was at least some of those packagings that were not quite as sealed. And in any event, he testified that in some cases, even through the vacuum seal, you can smell marijuana. Now, and I get that. You have all kinds of quarrels with what he is saying. But in the end, the district court saw this officer firsthand, was able to, consider his demeanor, the way he testified, and we're not. So ultimately, this is a credibility fight and a real challenge for you.
it is a credibility fight, but the district court can't insulate its credibility, its findings by calling them credibility findings. The court says that in McGee. And it also says that when there is objective evidence that contradicts the district court's findings, that this court can still find clear error. And here we have objective evidence in the form of a video, 2 body cam videos that contradict what his testimony was about the packaging and about other things as well. Because if you watch
video contradict his testimony that he smelled marijuana.
Well, in multiple ways. And I'll start with the most obvious one, which is that he affirmatively told Officer Bull when she asked what they were searching for, she was an officer in training helping him search the car, that they were not searching for marijuana. This was brought up during the suppression hearing, and Mullis never explained why he would say this if he had in fact smelled marijuana.
Well, he did say, they're searching for ecstasy, which he had found. And I understand the point that, it would maybe make sense if he smelled marijuana to say we're looking for that too. But
what doesn't make sense is that he says we're not looking for marijuana. That would be really bizarre if the officers have their heads in the car and they're able to smell marijuana. And he never offered any explanation for why he said that. That's not the only thing either, because Mullis repeatedly gave only the owner's suspended license as the reason for the stop. He never mentioned either a red light violation or marijuana smell during the stop. Even though any officer who had observed those things would have mentioned them under the circumstances.
Mentioned them to who? To Mr. Moses?
Well, most obviously to his supervising officer during this use of force inquiry that followed Moses' arrest. Because during that arrest, Mullis and another officer threw Mr. Moses down on his face. And Moses began complaining immediately. Like before they even had him on the ground, he's complaining. My daddy's license was the only reason for the stop, and you dropped me on my face. And he continues complaining about this for 3 full minutes in front of a dozen officers, including the supervising officer. But when the supervising officer walks up to Mullis and says, "Tell me what happened," again, Mullis gives the only reason for the stop as the register owner suspended license.
Well, you do have another reason. There was a red light violation was alleged here.
And he doesn't say that either. And that just doesn't add up, because under these circumstances, any officer who's being accused of seizing someone without reasonable suspicion that he had done something and then dropping him on the ground would have said what his other reasons were, especially if marijuana was one of those reasons, because all of these officers know if they smell marijuana, then they probably get to pat the person down, and they definitely get into the car to search them.
Red light violation, at least a justification for the stop?
It could be, yes. But again, it doesn't make sense that he doesn't bring it up when he's faced with all these opportunities to do so. In fact, he, when he also tells Moses 4 times that the suspended license is the reason for the stop, even though the first time he says that, he says, "I didn't realize you were driving the car." But then he keeps on saying that the suspended license is the reason for the stop after Moses.
But with respect to Moses, and again, he's got an explanation for everything, which I get it. It's frustrating. But with respect to Moses, he tells the court, the district court judge, well, I didn't want to heighten the attention of the stop by immediately referring to marijuana. I wanted to make sure that we were able to continue to process the stop. That seems to make some sense.
Okay, I have 2 points to make about that. First off is, why didn't he tell him about the red light violation? But my second point is, if you watch Officer Mullis's video all the way to the end, which takes place when he gets to the police station and he's getting Moses out of the car, Moses is still complaining about the fact that you stopped me for my dad's suspended license and then you threw me on the ground. And even then, Mullis doesn't say it's for any other reason. He says, "Yes, I stopped you because your dad's license was suspended. What's done is done." That's all he says. And that also doesn't add up.
But that's literally true. That's why he was stopped.
Yeah, but in the face of this accusation of you did something wrong because you dropped me on the ground after you stopped me for my dad's license, that just doesn't make sense. Like, this court can look at that and say that's not how a person would logically respond.
But can we, I mean, we could reach that conclusion. I grant you, we could look at all the facts and agree, hey, may not make sense to me that wouldn't have come up. But when there's testimony from an officer about the smell, and there is at least an explanation that he gives, what authority do we have to reverse that? That seems like a finding that is based on facts in the record. Maybe, maybe not the best reading, maybe equal that you could have gone the other way, but we're bound to affirm if the finding has any evidence in the record. Then how do we get to the point that there's none?
Well, I don't think that that's exactly right, because if you look at what the court did in United States versus Miller, the court reviewed the video, and basically I'm asking you to do what the court did there, which is review a person's words and conduct on a body cam video. In that case, it was the woman who was driving the car, and determine whether the district court's characterization of testimony about that conduct is plausible. And I'm just saying that Officer Mullis's testimony about what happened during that stop is not plausible in light of all of the things that you see on these videos that contradict it. There's even more than what we've discussed. Also, there are about 11 other officers on the scene, and 3 of them even had their heads inside of the car, but none of them mentioned marijuana until Bull finds this in a vacuum sealed bag. So it's really just not believable that out of all of these trained officers, Mullis would be the only one able to smell marijuana.
So what's interesting is what exactly are you challenging here? There are different stages of this stop. There's the initial stop, then there's an extension of the stop, there's then a frisking that goes on and a search of the vehicle. Are you contesting the initial stop basis?
No,
So then we're dealing with the extension of the stop.
that's correct.
With the marijuana, but there's also, I pointed to you out the red light violation.
Right.
And why is that not sufficient, at least constitutional, good constitutional basis for the extension of the stop?
Well, it would be if it really happened. We're not disputing that it would be if it really happened, but again, we
You're
dispute.
relying upon there's no corroborating evidence of it.
There's no corroborating evidence of it, but also there's actually conflicting evidence because of what he continually says throughout the stop and afterward, not just to Moses, but also to his supervisor about the reason for the stop under circumstances where anybody who had some other reason would have said so.
So, and at least in terms of understanding how that works, you got the initial stop, who says, okay, an extension, then the frisk. If the frisk, is there a basis for the frisk once you have an initial stop?
Not if the reason for the stop is the red light violation. So let's talk about the frisk. Because if you disagree with me about the marijuana smell, I mean, if you disagree with me about the red light violation, but agree with me about the marijuana smell, then you have to look at whether the frisk was a violation of his Fourth Amendment rights. And it was.
He consented to it, didn't he?
He didn't consent, either by raising his shirt or responding verbally after Mullis had already put hands on Moses' bare midriff, because no reasonable person observing the exchange with Mullis would interpret Moses raising his shirt as consent for a pat down. At that point, Mullis hadn't even asked for consent to search. He had ordered Moses to get out of the car and come over to the sidewalk, which is what Moses was trying to do when Mullis asked, "Do you have any weapons on you?" or anything like that. And this court has recognized in at least 3 published cases the law enforcement practice of asking people to lift their shirts in high crime areas to prove that they don't have guns on them.
He didn't ask them. He did it voluntarily.
He did it voluntarily, and people do that. In fact, an officer testified in the Peters case that what Moses did at lifting his shirt is the typical response when officers ask that question, and it means no.
Well, that's fair enough, but isn't that a court for a fact-finding matter for the district court to handle, and we review it for clear error?
It really isn't in this case, because there's no dispute factually about what happened. The question is, how do you interpret those facts? And also the question is, like, what was the scope of his intent? When he pulled up his shirt, he's obviously allowing the officer to look. So that is consent to allow the officer to look at his bare midriff, but it's not consent for a full pat down search. And I would just direct you to United States versus Neely in that context, because the court has to ask how a reasonable person would interpret the exchange. And whenever this court is reviewing reasonableness questions, it has to do that de novo.
And do I understand your position about his verbal consent to occurred after the officer began the frisk? Is that why you say it's no good?
That's right. He was already had his hands on him. He'd already begun. And when it was clear, that's the type of situation where it's clear that no matter what he does, he's going to get frisked. So that's not really consent in the first place, but also under Illinois versus Wardlow, the Fourth Amendment violation has already occurred because he's placed his hands on him without consent.
So counsel, do I understand you're saying the district court's finding of consent was we reviewed de novo?
That's right. Under these circumstances, because there's no.
What's the case that that says we review that finding de novo rather than for clear error?
So I cited in the briefs, it's an unpublished case where this specific thing comes up, where there's a video, and so the historical facts are not in dispute. But also just the fact that this is a reasonableness determination, and the court has to assess reasonableness questions de novo. Those 2 bases, and I believe I cited Bowman in support of that question. One more point with respect to the consent.
About that. I'm trying to understand that. De novo as to reasonable suspicion. But
Right.
fact finding regarding consent, isn't the case law pretty clear? That's clear error.
If there is a finding of fact, but what I'm saying is that here the historical facts are not in dispute. There's no question about what he did and what Mullis did. Mullis asked the question, he raised his shirt, nobody disputes what happened. But the question is, what did that mean? So when you're looking at what does that mean, I believe Carter is the name of the case. When you're looking at what that means, then you have to, and I see I've run out of time. Can I
No,
continue?
you can answer.
So the question is how a reasonable person would interpret those interactions. And when that is the question, then you have to apply de novo review.
All right, thank you, Ms. Hester. You've got some time left for rebuttal. Ms. Wood?
Good morning, and may it please the court. Julia Wood on behalf of the United States. As my friend concedes, and as this court has pointed out, this case turns on the district court's pure credibility determination as to Officer Mullis's testimony that he smelled marijuana and he saw Mr. Moses commit a red light violation before he pulled him over. This court grants those determinations the highest level of appellate deference and will reverse only if, in the extremely rare occasion where there is objective evidence that contradicts the testimony, or where it's so internally inconsistent or implausible on its face that no reasonable fact finder could credit it.
Facts. There's one fact initially when the stop is made, and he has a partner there, and yet he says later on he smelled marijuana. He doesn't say it then, but he tells the partner, "We are not searching for marijuana." Why would you tell that if you smell marijuana?
Your Honor, there are reasonable explanations for all of these facts. I do want to point out that the district court drew the inferences, and those were reasonable, and we defer to those. But I can address especially that testimony. This was an officer.
Inferences cannot create themselves, and you don't build upon inference on inference to get to that conclusion. The question is, he's got this partner there. I guess it's a training partner or whatever. And, he doesn't say anything about smelling marijuana at that time. It's much later that comes up. He even tells the partner when they're getting ready to do the car, "We are not looking for marijuana."
So I'll address that.
Which really contradicts saying later on, "I smelled it" before we went in.
I don't think it does when you look at the whole context. And I'll just go over kind of the exchange. Officer Bull was an officer in training, and she said, "What are we looking for in this car?" And Mullis said, "Drugs." She said, "Guns, drugs, weapons." He said, "Well, we're searching for drugs." And then she said, "Always that +1." Now, this is not in the record, but when CMPD officers are, conducting a stop, everyone knows that +1, that defendants are challenging the smell of marijuana as a basis for stops at this point because of the legalization of hemp. So officers often look for an additional factor. So she says always that +1.
You just made a point about this not being in the record. Why isn't it in the record? I mean, that explanation might make sense, but not for us.
It didn't come up, and it didn't come up at the suppression hearing. But it does make Officer Mullis, and even without that background knowledge, Officer Mullis says it's not for marijuana, it's for ecstasy. And he says you don't need that +1. So he's explaining to this officer in training, you don't need that +1 because I just found ecstasy on this person. And there's absolutely no doubt that finding ecstasy.
It seems like marijuana is fairly central to the issues before us. That smell of marijuana, there's the registration issue with the car that justifies the stop. And even if he rolled the red light, it's not necessarily you would get someone even out the car, but for the marijuana. Maybe you could, but it seems like marijuana is the whole reason you get Mr. Moses out the car. And so it feels fairly important. And do you agree with that? Just, I mean, is the smell of marijuana central to getting Mr. Moses out the car? I mean, after that, you got consent. After that, you got the body bleeding, but you got to get him out the car. And it feels like marijuana is the kind of central point of that. Do you agree with that?
I do agree with that.
And so go ahead. You want?
I was just going to say, and as my friend also concedes, it does, under this court's current law, give carte blanche to get him out of the car, frisk him, probable cause.
Fair enough. So if it's central, really all we have is his testimony about it. Now that's of course evidence, and maybe that's enough. The district court's finding, but it is odd that he never mentions it to anyone at the scene, not to Mr. Moses, not to any other officers. And as Judge Wynn said, he didn't just not mention it. He said, we're not looking for it. It seems like, I mean, I don't know what the facts are that would say, we can, second guess a district court in that time, but aren't we getting pretty close to them?
I don't think so, Your Honor. And I think when you look at the context, this was an evolving scene. After he got him out of the car, he did the frisk, which was justified. He had reasonable suspicion to believe he was armed. He had consent. He did the frisk. He finds the ecstasy, and that changes everything.
Is there any other officer who smelled marijuana?
Nobody says it on the body cam. We have the body cam of Officer Bull and Officer Mullis in the record. The fact that Officer Bull is in the car searching and says marijuana leads you to believe that perhaps she smelled it and just didn't. Officers are not necessarily in these developing scenes narrating every single thing that they are seeing or hearing or smelling.
Marijuana to get him out of the car. Do you need that? I mean, I need to know because it seemed to me your answer to Judge Quattlebaum's question was essential to smelling marijuana to get him out of the car. But if you have a red light violation, you have an initial stop that's legal. Do you need marijuana to say, get out the car?
Your Honor, thank you. I don't think you actually need the marijuana to get him out of the car in this situation.
That sort of goes against what maybe what I was reading you saying to Judge Quattlebaum, that you needed that. And so the question comes, if you don't need that, and if it is contradicted, why go there? You potentially have a red light violation. If you can get him out of the car, then the question comes, can you frisk him?
Yes, Your Honor. And I do think there are kind of two, and I apologize, I misspoke as I was speaking to Judge Quattlebaum. There are kind of two routes you can go. If you credit the marijuana testimony, that gives you, reasonable suspicion to frisk, reasonable probable cause to get in the car. Then you go the other direction. If you discount the marijuana testimony, you have the red light violation. Then you have both consent and reasonable suspicion to frisk. Still, I think the consent, he had both verbal and nonverbal consent.
What's the reasonable suspicion to think that he was armed and dangerous based on a red light?
So if you take away the marijuana, I do, it's a tougher reasonable suspicion analysis, but I think you still can get there with the body blading, which Officer Mullis testified about, and the district court also found very credible. And then also the fact that it's late at night, it's a high crime neighborhood, and there had been a call of shots fired. I realized standing alone that those factors would not add much to reasonable suspicion, but in this case where he has seen the body blading, I think we get to reasonable suspicion there. But I also believe that we're strong on the consent point. He non-verbally consented when the officer said, "Do you have any guns on you?" And he lifted his shirt.
Well, your colleague, on the other hand, says that means the exact opposite. He's only consenting to, I guess, a look-see, but not a full frisk.
So, Your Honor, just because that could be or is a common practice, there's nothing in those cases that says, and it does not convey consent. It is a fact determination. I do want to address that. This court reviews whether voluntary consent has been given for clear error. There's an en banc case, Lattimore, that's not cited in my brief, but I looked at this after I got the reply. Now, whether the scope of the consent, I do see the cases that say, and you need to apply. You need to decide whether an objectively reasonable person would understand that as consent, but this court does review for clear error the consent finding.
Do you agree that the statement of consent by Mr. Moses occurred after the officer put his hands on him?
It looks, he does kind of simultaneously place his hand on him. I don't think that was a search. He places his hand and he says, "Do you mind if I check real quick?" Which is a question. Moses could have responded yes or no at that point. It's up to this point, it had been a pretty cordial interaction, and Mr. Moses was cooperative. So I don't think the fact that he touched him, that touch wasn't a frisk. It wasn't, a search. The fact that he touched him, I don't think takes away from the voluntariness of the consent.
Can I follow up on Judge Quattlebaum's question and add this additional fact that, just causes me concern is not only did, there was no discussion about marijuana when the ecstasy showed up, but when the officer is asked by a supervisor, well, what happened here? There's no mention of the marijuana there either. You would think that would be the place to say, yeah, this started out as a regular traffic stop, but I smell marijuana, and things escalated from there. But he doesn't say anything about that.
I think that makes sense. And he actually...
What makes sense? What I just said, or you can
Sorry, what Officer Mullis did made sense, and he addressed that. He said he thought his sergeant was asking for a general rundown, not every detail. It's true that the initial...
one of the most important details.
It's true that the initial stop was because of the suspended license. And again, this is after he's found the ecstasy, and the scuffle began after he found the ecstasy. And
Did he mention ecstasy?
To his, no, he did not. So, I mean, that kind of weighs in favor of us. He doesn't, the ecstasy at this point is the most important thing, because that is actually what, he pulled out of his pocket. That's when he went to detain Moses, and when Moses then began to struggle. And he didn't mention that either.
What's the case where a officer says, "I smelled marijuana," where we could, and the district court finds him credible, that we could say that's, clearly erroneous? I mean, how much absence of other corroborating evidence, does it have to be? What is there a case where an officer says that we could reverse?
I can't think of a case, because I think it would have to be the finder of fact is there and doesn't smell marijuana. Because it can't just be because a district court is entitled to, credit the testimony of even if he had said, "I didn't smell marijuana," and then he comes into court and says, "I smelled marijuana." The district court is entitled to credit that testimony. So I think it would be a very tough, a tough case. But there are examples, I mean, of in the.
But what about if, he says, "I smelled marijuana," district court finds it credible, and there's, video cam evidence that someone asked him if he smelled marijuana at the scene, and he says no. In that case, could we vacate or a suppression, a denial of a suppression?
I don't think so, because the district court is the finder in fact and the one that is making this determination of whether he either lied on the stand or he lied in the body cam footage. And so the district court is the one who's observing the demeanor, the inflection, the cross-examination. So I don't think in that situation that this court could reverse.
It just seems to me that you spend a lot of time talking about smelling marijuana. There's a lot of contradictory evidence, as pointed out by both Judge Quattlebaum and Judge Diaz here. And yet, it seems pretty clear that, at least under the United States Supreme Court law, I'm talking about the Maryland versus Wilson case, once you have a traffic stop violation, police officers may, without violating the Fourth Amendment, order the person out of the car. If you accept that and you say there's a red light violation, then it must be something here that does not give you a lot of comfort in believing that that red light violation occurred. Because that alone, at least under this Maryland versus Wilson, would get him out of the car. Once you get him out of the car, then you have some evidence there of consent, because he asked him, "Do you want to do it?" He says, "Yes." you can consent, you can search me or whatever. That's basically what, now whether or not that goes to the full scale or not is another question. But you spend a lot of time talking about marijuana on a case where, and we don't often see it like this, it looks pretty strong, the evidence that that didn't happen, that he didn't smell marijuana. And if he did, it's more of a looking back determination as opposed to a forward determination, because the video cam, and I've seen that video cam, does not support it. It is not there. I don't know how you can look at that and say that happens. And you got direct indications to his partner, no, we're not searching for marijuana. Now, why in the world would you say that if you smell marijuana? So, but the point, going back to the original point is, do you have to go there? Because you are going there very strongly, but it would seem to me, if you have another path, why wouldn't you take that?
Your Honor, I think we're both strong on both paths. And I think that
You're strong, but you obviously were not listening to me.
I apologize, Your
And I'm
Honor.
saying you obviously didn't look at that video, and you're not looking at the evidence objectively. And sometimes you have a feeling it's strong and you want to support the trial judge on it. But then if you have I think a stronger avenue that might exist, why wouldn't you focus there? Because it will get you to the same place.
It will get us to the same place, and we're strong on the red light violation. Then I think, the marijuana smell.
On the red light, if you're on that route, you have to have justification to frisk. I mean, the marijuana
Yes.
gives you immediate justification for frisk. Judge Wynn's right. Yeah, he can get out the car based on the traffic violation, but that doesn't give you the right to frisking necessarily, right?
Right.
So you
right.
have to go to consent there.
That's exactly right, to consent or reasonable suspicion without the odor of marijuana.
Do you contend you have reasonable suspicion? Assume there's no consent. Assume that we disagree on the marijuana. Is there any other reasonable suspicion?
I think there is, and that's where, we do have the consent, so I don't think we need this.
Right,
But
I understand that.
but the body blading, which the district court credited.
It's body bleeding.
Body blading is, Officer Mullis testified that it's when a defendant kind of turns their body away to try to hide contraband. So when he was getting out of that car, instead of the way that, you get out of the car, you turn around to grab your cell phone. Instead of getting out and reaching back through your legs, it was as if he was trying to keep his body forward. And that made Officer Mullis suspect that he had something
He
on.
grabs the phone between his leg, and you call that body bleeding.
Yes, that is what Officer Mullis.
Have the phone between your leg, you're going to have that as a basis for reasonable suspicion to do something else simply because you're grabbing a phone between your legs.
In an extremely unusual manner was Officer Mullis's testimony that the district court credited. And the district court actually said, this is the most unusual way of getting out of a car that I've ever seen in all my years of doing this. So the body blading combined with
on the video,
it is on the video, yes.
and it shows him reaching in that particular manner.
It does, yes.
Is that an expert opinion? Does that have to be vetted through as an expert opinion, or is that a matter of fact?
I think that's a matter of fact because it goes to Officer Mullis's years of experience, which courts defer to, and these kinds of factual findings, the law enforcement experience on the job is part of the factual determination. So I do think, we have our path with the marijuana, which I understand, Judge Wynn, you do not think is strong, but we also have our.
I think I'm pointing there because part of it is there is a public perception. And then one of the things that's come up, if an officer says, I smell marijuana, it has become sort of a nice way to ease into it. And people know this. Officers know this. And under these circumstances, this doesn't help for someone to later on come and use that as a justification, knowing it works. Mm-hmm. That's the problem you got. It may actually be that happened, but the facts are pointing to it that would cause a serious problem of a public policy problem at the very least, where you have post hoc justifications that are for an otherwise unlawful search of a person.
So then I think we are strong on the red light violation, and then you have the consent for the frisk, and then you find the ecstasy, and you have the probable cause to search the car. So I think either way this court goes, and you know, at the heart of this is the credibility determination on both the red light violation as well, which this court would not overturn under these circumstances.
You have anything else?
No, if the court has no further questions,
Thank you very much.
ask that you affirm. Thank you.
I'd like to start kind of where Judge Wynn left off, which is talking about this marijuana smell justification. I mean, the government comes in here and gives you an explanation for what happened in that car when the other officer said it's the +1. That's not in the record. What's also not in the record is that officers ask people all the time, where's the marijuana, when they smell marijuana. I mean, we see that over and over in these videos. I'm sure all of you have seen it as well. And people confess because they don't think they're going to get arrested for having marijuana. So I would bring that up as another reason why it's just not believable that he doesn't ask people about marijuana.
Basis based upon the traffic violation to have him get out of the car. Then it seems to me that the contention is that marijuana odor, as Judge Quattlebaum alluded to, is a basis for the reasonable suspicion for that leads to the frisk. And without that, what would be, what's the problem with having a red light violation, the so-called body bleeding, maybe, and there are gunshots that have been fired before this. There's one other point that I didn't understand why they didn't make a deal of, but it seems like to me he was parked somewhere when the officer saw him. Seems like they said in the middle of the road. I don't understand what that meant. But when you add all those things together, without the marijuana evidence, is that enough for reasonable suspicion?
It's really not, and I would like to talk about that because
Let's not forget that this was a blatant red stop violation, right?
A what?
Blatant red stop violation.
I don't know what that means.
I don't know either, but that's what he said.
Okay, so let's start with the red light violation, because even if he saw a red light violation, he offered no explanation for why that suggests the person is armed and dangerous, and that's what he's got to have reasonable suspicion of in order to pat somebody down. He also talked about this blading thing, but the government doesn't explain how Mullis could still suspect blading after Moses got out of the car and obeying his commands, faced him directly and exposed his entire midriff. I mean, that is completely inconsistent with the idea that he was somehow blading when he got out of the car. Also, with respect to
what, I mean, is it really, I mean, assume there's something called body blading, and it's something that people might do to shield either contraband or a weapon from the officer's view. I mean, pulling your shirt up might be inconsistent, but it doesn't expose all the areas that a weapon, for example, could be in.
Well, that is true, but that's not what he testified to about the blading. He said the blading was suspicious because he was hiding the front of his body from me.
Yeah.
But then he walked around the car and he showed him his whole front of his body. He raised his arm and then he pulled his shirt all the way up. And I mean, really exposed like a foot of his midriff to the officer. So that makes it really hard to believe that he was actually blading when he got out of the car. And Mullis also admitted guilty people don't typically drive toward the location of a shots fired call, as Moses was doing. And then there's this whole slow roll bit, but the court's decision in Miller really establishes Moses wasn't slow rolling when he stopped 13 seconds after the blue lights came on. The court can see for itself on the video, Moses doesn't seem especially nervous. And also, Officer Mullis mentioned that he gave conflicting stories about where he's coming from, but the work ID hanging from his pants corroborated his explanation that he was leaving work. But also, what does this have to do with whether he's armed or dangerous if he is not being completely accurate about his travels? And again, Mullis never explains why that has anything to do with a suspicion that he's armed and dangerous. So, if the court agrees with me that there's clear error on the marijuana smell, but for some reason disagrees with me about the red light violation, still, that pat-down search was not justified, and everything that flowed from that and from the stop, it has to be suppressed. The marijuana smell that doesn't exist can't get him into the car to search the car, nor can the pills that were recovered from this unlawful pat-down search get him into the car, because all of that makes the search of the car the direct result of this unlawful conduct and fruit of the poisonous tree.
You're saying once there's an initial stop, and even without the marijuana, there's a red light violation. And if this Maryland versus Wilson case says you can ask an individual to come out of a car.
Correct.
At that point, are you saying at that point, the officer, that the defendant can't consent to being frisked? In other words, you can't even ask him? Because that's what he did. He says, can I search you? And you're saying at that point, he cannot ask without reasonable suspicion, can I search you?
No, I think you're misconstruing what I'm saying. Our position is that he did not consent. That motion of lifting his shirt is a well-known response to that question.
But that's not my question. I understand that. But my question is, can the officer ask him?
For consent?
Yes.
If he has a legal basis for the seizure, but if he doesn't,
There's no legal basis.
No.
He cannot ask him.
if he is,
He cannot say, may I search you?
if the seizure is already illegal at that point, then the consent it's more fruit of the poisonous tree. It never would have happened but for.
But the stop violation would have been the basis for the seizure, at least to continue the investigation, right?
It could have been, if the court disagrees with me, that was clear error. I think that we're all on the same page with that. Right.
No, I'm trying to understand what you just said.
Okay.
The stop violation, was that the red light violation, which makes the seizure okay because of the stop? Once you get there, my question is, even if you don't have reasonable suspicion beyond that, an extension of it beyond that, is the officer prohibited from asking, may I search you?
Not if he really saw a traffic violation. He can order him. He can order him out of the car at that point and ask for consent.
Yes.
Just,
And so if he does that and the defendant then says, yes, you may, then what's the problem?
that wouldn't be a problem, but that's not what happened here.
Okay, thank you.
Thank you very much, Ms. Hester. I want to thank both counsel for their fine arguments this morning. We'll come down and greet you and move on to our second case.
All rise.
Thank you.
Always a pleasure. How are you?
Thank you. Good to see you.
Thank you, Kelly.
Thank you.
Good job.
Thank you.
You seated?
The second case is 25-2199 and 25-2200 FS Medical Supplies LLC versus Tanner Pharma UK Limited. Mr. Yalowitz, whenever you're ready.
Thank you, Chief Judge Diaz, and may it please the court. I'm Kent Yalowitz from Arnold and Porter on behalf of FS Medical. The court should reverse the district court's judgment because section 1332A of 28 USC A3 provides subject matter jurisdiction. Clause 1 of Section A3 deals with citizens of different states. The language of the text is between citizens of different states. Congress enacted that text in 1948 at a time when it had an established legal meaning. The established legal meaning was centuries old from U.S. Supreme Court cases. And that legal meaning, and I'm reading from Greeley, the Greeley case, Greeley against Lowe, was no defendant shall be a citizen of the same state with the plaintiff, but otherwise there is no limitation upon such jurisdiction. In other words, the door closing fact is if there are two citizens from the same state, then there's no diversity jurisdiction. But the fact that a citizen might be a citizen of a state and a foreign country was never a door closer under Supreme Court precedent.
Do we look at that phrase in A3 the same way we would look at that phrase in A1?
Yes, it's an identical language. It was lifted from A1 and used in A3. So the inference is Congress intended to continue the same meaning that it had developed in A1. Absolutely. And so if you have a case where, say, a Texas plaintiff, like the Leland family who lost their father in a plane crash, sues a defendant from Delaware and Ontario. That was the Boeing of Canada. They were a Delaware corporation headquartered in Ontario. Your intuition is that is a diversity case. It's an out-of-state defendant. There's no overlap between the state citizenships. That's removable, and that's what Boeing of Canada did in the Leland case. The court upheld jurisdiction, and when the party opposing jurisdiction argued that the foreign citizenship contaminated the state citizenship of the corporate defendant, Judge Jones said that's counterintuitive, and there's no support for it in the case law. Judge Edith Jones.
It does seem like there are some problems here. You're making a very convincing argument, but when you look at A1, at least A3, the whole business of that being citizens of different states seems to be established. But the question really comes to is on A1, and that is, you have any cases that suggest that if one of those parties is a business entity with dual citizenship, does that apply in that instance? That's the question, sort of unique in this question, in this case is, I mean, you got one of the parties, the business entity part of it, the LLC, as I understand, is a dual citizen.
Right. So the answer is yes. There are cases that say where you have a dual citizen business entity, foreign and domestic.
What's that case?
So the Leland case.
That's unpublished.
That's true.
Circuit at that.
Well, it's not binding on you, but it's persuasive.
Unpublished.
Unpublished, but important. Mickey Leland was a serious person.
But you got something stronger in the Leland case.
Indeed, I do. I have the Tango case, which is the Seventh Circuit case written by Judge Posner. In Tango,
Was that issue squarely presented in that case? I mean, it was almost like an afterthought without much analysis. And I get it, Judge Posner is someone that we probably should listen to very carefully as a general matter, but the precise issue that you're arguing here today was not presented in that case, I don't think.
well, I agree with you. It was not presented in the way it's presented here and in the way it was presented and rejected by the Fifth Circuit. But it is a subject matter jurisdiction issue. And when you are evaluating subject matter jurisdiction, you have an independent duty to evaluate it, you, the court. And so we know that Judge Posner and Judge Wood, and I forget who the third judge was, but it was a very, very distinguished panel. They're looking at subject matter jurisdiction. So they can't, if they think that that a dual citizen contaminates the state citizenship, they wouldn't say, oh, the parties didn't argue that. I mean, they have an independent obligation to come to the right decision. And then in the Intech case, the Judge Easterbrook, admittedly this is dicta, but in the Intech case, Judge Easterbrook is describing our situation exactly, A versus B and C. A is a dual citizen, California and Mexico. B is Illinois and C is Canada. And Judge Easterbrook says in that case, Section 1332A3 provides jurisdiction. Again, not holding, but persuasive.
We have a series of cases since then, though, at our circuit and at the Supreme Court that says that we can't, for purposes of jurisdiction, disregard either the foreign or domestic aspect of citizenships of LLCs.
Right.
And so how does that work in this context?
So I want to take you through, first of all, I think it helps us. It helps our side, because what that means is that FS Medical is always a citizen of California, it's always a citizen of Texas, and it's always a citizen of China. It's always all of those things all at once. And the question is, do you, my friends on the other side would say, you have to treat it, you have to pretend that it's not a citizen of a state when you're testing it in some way. And so therefore it doesn't count as a citizen of the United States. It's like a contamination theory, like the foreign citizenship contaminates the state citizenship, and so it doesn't count. That's their theory. That's the theory that Judge Jones rejected in the Leland case. And the only way to get there is to pretend that it's not a citizen of Texas and California. And I really want to emphasize the reasoning of this court in the General Technologies case, because I think it's extremely helpful. If you remember the General Technologies case, that was a party that had that was a nominal defendant, and so they might be realigned as a plaintiff or as a defendant. It was not clear which they should be aligned as, and the court went through both permutations, and the part of the opinion where the court said, let's treat them as a plaintiff and see what happens is really helpful to our side. The court, and I'm looking at pages 120, we're carrying over to 121 of the General Technologies case. It says, if we align EXG as a plaintiff, that's the dual citizen, then XRO, Columbia, and EXG, Columbia and Virginia, are suing the various defendants, Virginia. And you can see that diagrammed on page 21 of my brief. And then this is the critical point. They don't say, oh, and the dual citizenship means it doesn't qualify as a citizen of a state. They don't say that at all. They say Virginia's presence on both sides of the controversy destroys diversity. And then the court cites 1332A3, the statute that we're traveling under. And the court quotes it, and it says diversity jurisdiction exists between citizens of different states, and that's italicized. And so the problem in General Technologies was that you had a dual citizen, which had Virginia citizenship, against a Virginia citizen. And so you can't have citizens of different states when you got Virginia on both sides.
Well, I would suggest that that's exactly what your colleagues on the other side are doing with respect to the LLC here. They're testing the citizenship of all three of those members, two domestic, one foreign, Chinese, and asking whether or not each one of those satisfies the complete diversity test. And they're saying no.
Yeah, and I think that I admire their perseverance. They have a fact in search of a legal theory. They jumped on this and they said you can't have aliens on both sides.
Well, that general text says that, doesn't it?
You can't have aliens on both sides unless you have citizens on both sides. But they kind of overlooked A3, and then when the district court decided their case, the district court said, well, FS Medical can't be both an alien and a citizen. It can't be both a citizen and an additional party. And of course, TPUK is the additional alien party here. So the defendants have abandoned that, and now they've come to a third theory. And
What does additional party mean?
yeah, I think that,
I mean, under Tango, it seems like anybody's an additional party. So I don't know who's additional suggests something other than maybe a primary or a real, I don't know what it means. Do you have it? What does it mean?
well, they have to be a real party in interest. They can't be a fraudulent joined party. They can't be.
Okay, but that's a weird way of describing additional as not fraudulent.
The text says additional party that is a citizen of a or subject of a foreign state. So the difficult question, which we don't have here, is what do you do in a two-party case where you've got a dual citizen on one side and like a New Yorker on the other side. So there's only one foreign citizen and it's a dual citizen. Is there diversity in that case? And the Seventh Circuit seems to have suggested in MAS, which is cited in the briefs, that a dual citizen, that a two-party case doesn't have an additional party.
Is Tong an additional party?
I'm sorry?
Tong.
No, we're not. That's not our argument. Or we're not arguing that
Party at all.
we're not arguing that she's a party. We are arguing that her citizenship is immaterial to the question whether FS Medical is a citizen of a state.
But she's part of a business entity.
Correct.
And where you were going to general technology, but it seems to be that for business entities, all of their citizenships have to be considered.
Correct. Right. All of their citizenships, all of the time. And so they're always a citizen of a state. They're always a citizen of a state. And I want to add, one other case to the mix, which is Chief Justice Marshall's opinion in Bank United States against DeVoe.
Oh, you're going way back, or is it
Well, actually, we went back to the founding in our briefs. We talked about the purpose of diversity. And obviously, this case is in the heartland of the purpose of diversity, which is you've got an in-state powerful interests against out-of-state defendants in an important case. And that was Madison at the Virginia Convention. That was Hamilton in the Federalist. That was James Wilson in the Pennsylvania ratifying convention. So the purpose of diversity is obviously met here. And then
take you back to the question I asked earlier, and I think you conceded this, that let's put aside your client's LLC makeup doesn't include a foreign member. So we have an LLC with members of Virginia and North Carolina, and then a citizen, a plaintiff, and then a defendant, Virginia citizen. In that scenario, there would not be diversity.
correct.
So
There's not citizen
why?
difference.
Because you're testing each one of the members against the V on the other side, the defendant. Why are we making an exception for the foreign member?
Well, so the foreign citizenship is not material to the question whether they're a state citizen. It's just like, we're in North Carolina, so I'll use a basketball analogy. Kyrie Irving is a citizen of Australia, it turns out. So he played on Team USA. His Australian citizenship wasn't disqualifying. He was still able to play on Team USA because he was a citizen of the United States, and that's what counts under the Olympic Charter.
Kyrie Irving's not suing anybody.
Right, but
Yeah.
But there were things about him that are immaterial. It was immaterial that he was a citizen of Australia, immaterial to the rule that he thinks the earth is flat, immaterial to the rule that he dropped out of Duke. There's a lot of things about him that aren't part of the test. There's no case that says, oh, you test the citizenship by pretending it's not a citizen of a state and then seeing what happens. That's never been the test. I see that I've exceeded my time.
You've got some time left for rebuttal.
Okay, thank you very much.
Thank you. Mr. Ellis?
Good morning, Your Honors. May it please the court, Jonathan Ellis, on behalf of the defendant appellees, TPUK, Tanner Gap, and the Bournes. Section 1332A3 vests district courts with diversity jurisdiction over disputes between citizens of different states with additional foreign parties. As I think the discussion this morning has already indicated, the dispute here before this court is really about that first prong, and whether a dispute, a case with a sole plaintiff that is a business entity with citizenship, domestic and foreign citizenship, can ever satisfy, can ever qualify as a dispute between citizens of different states. Our answer is no, and our rule is the one that we also derive from general technology applications, from Slavchev and from this court, from Grupo, and from Cardin.
Is the input on the A3? When you look at this statute, A1 talks about the citizens of different states. We've been clear on that. And with 3 says citizens of different states in which citizens of subjects of foreign states are additional parties. What's the import of the additional party part there?
Yeah, so the import of that is that if you can identify a dispute between citizens of different states, then unlike under A1, that you can have additional foreign parties. That is to say, literally other parties, not just citizenships of the same party, that can then ride along in that case. And so I understand if they could identify a dispute here between citizens of different states, then TPUK's presence as a foreign defendant would not destroy diversity under A3. But the problem for my friend is that they can't identify a dispute here between citizens of different states because under general technology applications, in order to satisfy or to invoke the diversity jurisdiction of a federal court, a unincorporated association must satisfy the diversity test for each of its citizenships. So if you look at, now my friend focused on the part of general technologies that aligned EXG as a plaintiff. I think that's consistent with our view, but I would like to point the court to the next paragraph where the court aligned EXG as a defendant. And in that case, it said, or if it could have relied on there only its domestic citizenship, and it could have invoked and satisfied the diversity test of 1332A2 because it would have been a dispute between a foreign citizen, Colombia, and only domestic citizens. But the court said that because when you take into account its foreign citizenship, it is now a dispute between two foreign parties. And that doesn't fit within any of the buckets of 1332A. The same analysis was done in Slavchev. That was a case about a dual citizen corporation. If that dual citizen corporation could have relied exclusively on its domestic citizenship, that would have been a dispute between a Bulgarian citizen and a Florida citizen. That would have fit again within 1332A2. But when the court kept in mind and took account of its foreign citizenship, then it did not qualify under any prong of 1332A.
You're saying general technology in Slavics is not consistent with, or at least they don't follow, wasn't followed in the Leland case out of the Fifth Circuit, that unpublished case.
No, it was not. And I want to address that decision. It is unpublished, so I think there's something to it, but I'll take it on head on. And the reasoning, because Judge Jones is a great jurist and we should look at it if it's persuasive. But here's what Judge Jones said in Leland. If upon inquiry, the court determines that a domestic corporation's worldwide principal place of business is not in the United States, then the foreign principal place of business cannot be considered for diversity jurisdiction purposes. Cannot be considered for diversity jurisdiction purposes. That was the rule from the 11th Circuit at the time, and it was the rule in several other circuits. Congress has abrogated that rule. 1332C1 in 2011 was amended to make very clear that for corporations, you can't ignore the foreign citizenship. And then this case, this court in general technology applications made clear that for unincorporated associations, you can't ignore their foreign citizenship. My friend made an analogy to an individual dual citizen. In general technologies, this court said, although individual dual citizens can and must ignore their foreign citizenship, unincorporated associations are different. They may not. And so when you take account FSMS's foreign citizenship, this is not a dispute between citizens of different states, and therefore they can't invoke the diversity jurisdiction of federal courts.
Well, let's move on to another distinguished jurist, Judge Posner, in the Tango case. Did that panel just overlook the jurisdictional problem?
With all respect to Justice Posner, yes. The very first paragraph of that decision lays out the question they're going to answer in that case. Here's what he said. While the U.S. parties are diverse, there are UK citizens on both sides of the case, and we must decide whether that destroys diversity jurisdiction. He was only asking this question that was open at one time, but no one's disputing now, whether the additional foreign parties have to be from different foreign states. And he said, no, they don't have to be. We don't disagree with that. He never considered whether the dual citizen sole plaintiff in that case could be treated as solely a domestic citizen. Obviously, he wasn't doing that. Or could be disaggregated, which I understood to be one of my friend's arguments that I think he disavowed this morning, and satisfy A3 in that respect. I will note that Tango, in addition to not actually passing on the question presented here, was also issued before Grupo, where the Supreme Court made clear that unincorporated associations have to account for all of their citizenships, and they must be treated as only one party when asking about diversity jurisdiction, not multiple parties. That's what courts have said since then, when they've looked at Tango and said that doesn't control in this case. Tango didn't consider Grupo. Tango didn't consider the actual question about disaggregation that I think my friend has advanced in the briefs, although perhaps backed away from here.
So it doesn't sound like you're disagreeing that this case would kind of from the policy standpoints fit well within diversity jurisdiction. It's just, you're saying it's a matter of, definitionally, we don't have citizens of different states because we have to consider the dual citizenship.
We are not making a policy-based argument. We are applying the rules as we understand.
This would be at least from that standpoint, a case where diversity would be consistent with those purposes. You just think it doesn't technically comply with the statute.
And what I would say on the policy concerns, I understand them, that is that Congress doesn't pursue any purpose at all costs. And there are other considerations here. If there's anything that's evident from Congress's activity in this area over the past 5 or 6 decades, is that one of the purposes of Congress is to protect to guard jealously the federal district court's jurisdiction and dockets from state law claims like the ones at issue here. And in particular, to protect the limits on diversity jurisdiction with regard to dual citizens. We cited the 2011 amendment in our case to see one. I think that is the most relevant of those amendments, but it's not the only one. Congress amended 1332 in 1958, in 1964, in 1988, in 1976, and in 2011, every time restricting diversity jurisdiction. As a result, I think what you find is it's not hard to come up with hypotheticals where you might think that the local bias concern would apply. I mean, take just an iteration of this case, right? If FSMS had 14 partners or members instead of 4, 13 were California citizens. This is a company that operates exclusively in California, does all its business in California. They can't invoke diversity jurisdiction in a case against North Carolina citizens if they've got a member that's a North Carolina citizen with 2% interest.
So it's the Chinese dual citizenship which China creates the problem in this case.
It is the Chinese citizen that raises the problem.
When you're looking at jurisdiction, and you talked about Congress, at the end of the day, you can bring this action in state court. Is that correct?
That's correct. This action could be filed in state court today.
It seems odd that you can bring a case in state court regardless of whether or not there's dual citizenship, you got an LLC involved or whomever with China, but you can't bring it in federal court.
I don't think that's odd at all, Your Honor. I mean, diversity jurisdiction is always an alternative forum. You're always asking, do the federal courts need to provide another place to have state law claims heard? North Carolina courts are perfectly capable of resolving these questions. And I said, I think this case could be filed today. Now, you won't be surprised to know that we have concerns and disagreement about tolling and the statute of limitations. But I think if you ask
Is there a statute of limitations problem in this case?
We think there is. But if you ask my friend, he'll say, I understand their position to be that that tolling applies to every one of their claims. That's their position in the case that they filed in FSMS 3, the one that's still pending in the Western District. And I expect, I don't want to put words in his mouth, but he would say the same thing if he filed this case today at state court.
But I mean, whether or not there's tolling may kind of affect some equities and stuff like that, but that can't be the basis of whether there's jurisdiction or not.
No, absolutely not. The basis of, yeah, I'm sorry.
Because it could have, I mean, the real point is it could have been brought in North Carolina. Whether it could be brought today or not, based on statute of limitations, it may be an issue, but.
That's correct. Yeah, no, my point is only that if the concern is, and as expressed in the briefs at some point, that they're not going to have a place to hear the merits of their claims. They certainly had a place to have the merits of their claims heard at the outset of this case before they falsely certified to the citizenship of their members, and they alleged repeatedly that they had diversity jurisdiction without foreign citizenship. And I think, as I say, I think they think they have a place to litigate that now.
I suppose had this been brought into state court, you'd been the one asking to have it removed to federal court.
You know, this case, one iteration of this case, the very first one was filed in state court in California. And we removed because we understood the allegations to be about that we had diversity of citizenship. The court said, hey, could you help us? I need to know the citizenship of SFMS. We asked them, what is your citizenship? They didn't answer. We did our own research and we told the court as best we could. We think that there's diversity here because their citizenship, as far as we can tell, is Texas and California. We were wrong about that. And that case ultimately was dismissed on personal jurisdiction grounds. But I think it goes to the point that I take in the reply brief that somehow we're the ones at fault here, that the court should then go to its backup arguments here and dismiss TPUK or rely on North Carolina Rule 41B. We've got lots of fundamental problems with those requests, but at bottom, they're both discretionary ones. And I think the only party here to blame for the wasted efforts, for the wasted time, for the fact that we don't think the court has jurisdiction over this case anymore is FSMS and its failure to properly and accurately certify its citizenship.
So does I get the discretionary nature of those alternative arguments, I guess, but once you get to them, they're discretionary. But if we don't have jurisdiction, can we do? What's your position on whether we could engage in the discretion in the first place?
So as to Rule 41B, we do not think a district court or this court could rely on that without subject matter jurisdiction. There is a narrow exception, right, for collateral matters, those things that are attendant to the presence of a live controversy, is how the court said it in short. But those are things like sanctions, maybe protective orders. There's a dispute about that. It is not about the ability to toll a statute of limitations. That is beyond the court's subject matter jurisdiction or power without subject matter jurisdiction. Now, I don't dispute that the Rule 21 or the sort of Rule 21 analog under Newman Green is available, even if the court doesn't have subject matter jurisdiction. Indeed, that's the point of relying on Rule 21 sparingly, the court has said, is to preserve diversity jurisdiction. There, I think the problem is, number one, that my friends forfeited that argument by not asking for and not moving for the dismissal of TPUK in the district court after the jurisdictional problem here came to light. In fact, what they did instead was to file another lawsuit, right, in the Western District after divesting themselves of their Chinese citizenship or attempting to divest.
You know, it's the Newman Green case. It provides some support, but it seems strange that a federal court that didn't have jurisdiction could operate and that could do something like that, and. Supreme Court guides us if that's the case. But does the recent Hayne case call that into question at all, in your view?
I don't think it calls it into question. Hayne did refuse to dismiss the party. He didn't do so on subject matter jurisdiction grounds. I think the only relevance we've talked about in the 28J letters of Hayne Celestial here is that it made sure that the party had not forfeited the argument before it went on to consider whether to dismiss a party under Rule 21. Here, Judge Reitinger couldn't have been more clear that to the extent that their invitation or their suggestion to the district court that it might invite a motion to dismiss TPUK if it didn't find subject matter jurisdiction was not compliant with federal rules, in particular local rule 7.1 C2, and therefore it was forfeited. I think that this court shouldn't take up that forfeited request for the first time.
Judge Wynn asked you about if this case had been brought in state court, that you likely would have removed based on your assumption that there was diversity jurisdiction if that, after some time, it turned out to be incorrect and the court dismissed the case for lack of subject matter jurisdiction and the equities weren't as one-sided as you say they are in favor of your client, the district court, the district court, yes, still would have been powerless to extend the statute in that instance?
Yeah, as we've explained, I think there's at least two different grounds that if the district court could not have relied on North Carolina Rule 41B here. I mean, it is true that diversity jurisdiction and subject matter jurisdiction just has harsh consequences sometimes because it is a fundamental limit on the power of federal courts. But I don't think that either the subject matter jurisdiction analysis goes the other way if we're the ones to have removed. The North Carolina Rule 41B is just beyond a court's power that doesn't have subject matter jurisdiction. And as we raised in the 28J letter last week, I think, in fact, North Carolina Rule 41B doesn't apply at all under the Supreme Court's decision in Burke v. Choi from a couple weeks ago. What that decision says is that we've got a federal rule on point that's inconsistent with a state law or a state rule, that the federal rule applies regardless of whether you think of the state law as substantive or procedural. Here, there's a federal rule on point. It's 41B. And it doesn't grant powers. The district court's the authority to toll statutes of limitations after an involuntary dismissal. I think that's the rule that should apply. Now, my friend in his response to 28J points to this court's decision in Shuford from 1981, putting aside the skepticism that one should have about whether a decision from 1981 could foreclose a decision under a 2026 Supreme Court decision. That case doesn't speak to the issue at all. The only question in Shuford was a question of state law about when the automatic tolling provision under North Carolina Rule 41A began to run after a district court entered a voluntary dismissal under federal Rule 41A.
So what is your, the exception that's being used here with respect to not applying the Rule 41 is that it can only apply to collateral matters. So how do you define that?
Yeah, so I can't do better than this court. I think in the short case, this is a case from this court in 1990. It's an unpublished case. I just think it's a persuasive one. It says that the court's has inherent authority to engage in those judicial acts attendant to the presence of a live controversy before the court. And so this is really about governing the procedures before that court, the parties before that court. As I said, I think the prime example here is sanctions, right? You cannot lie to a court with impunity just because that court doesn't have subject matter jurisdiction over the case. This is, I think, a far cry from that. We're not talking about what's going to happen in the district court or in this court. We're talking about what's going to happen in another case, in another court, going to the merits of that dispute. That is well beyond the collateral power, the inherent authority of a court to attend to the controversy before it.
And yet we've had a number of district courts grant such relief.
I don't think so. The court has pointed to, though my friends have pointed to a couple of cases that say that post Clark v. Valesky, I think it says that the courts have assumed that federal district courts could grant that relief. Both of those, I think both cases, it's Clark and Huang, the court actually did not grant that relief. And then actually, if you take a look at those cases, Clark in particular says, we're not even assuming that a court could grant that relief. We're not deciding what the rule was. We're just saying if the court does not grant that relief under North Carolina Rule 41B, then you can't take advantage of the tolling.
What type of entity is TPUK?
It's a corporation, Your Honor. It operates in the UK. It's an ongoing concern. It's worth pointing out with regard to the dispensability argument, it is sort of the central actor in this case, right? It is the entity that entered into an agreement with the UK government to supply COVID tests. It's the entity that entered into the contracts with Orient Gene to get those COVID tests in order to supply them to the UK government. It's the entity that made the profit sharing payments to FSMS that they say were insufficient. The entity that issued the dividends to the Bournes that they say are void. It is really the central cog in this entire dispute, which is why I understand FSMS, every time they filed this case, now they filed it 4 times, including once after the jurisdictional issue came to light, has named TPUK as a defendant. It's the only party that's been named as a defendant in every one of these suits.
So bottom line in this case, if Tom himself was a separate party rather than a member of FSMS, then there would be jurisdiction.
I think that's right. If Tom could qualify as an additional party under A3, then I think you've got an entity, a dual citizen entity, like we thought we had for 5 years, that only has domestic citizenship. And then you've got a dispute with 2 other domestic citizens that are from different states. That's a dispute between citizens of different states. The problem really is the fact that we didn't know that there was a citizenship, that the FSMS had the citizenship of Ms. Tong until just recently. And when you do that, when you add that in as the same party, not a disaggregated party, this is no longer a dispute between citizens of different states.
But that seems somewhat odd. You don't have jurisdiction based upon that rather minimal distinction.
And so I think it's not unusual to find cases where the policy rationale of the 2 cases look very similar, but Congress has not extended the diversity jurisdiction to that scenario. If you look at the court's decision, the Supreme Court's decision in Cardin, there's a passage at the end that I think is particularly relevant here. It gets to there and it says, look, we're going to treat every single partner of a partnership to be a citizen, a member of this partnership, and therefore a citizenship of that partner. And then it says, you might think that the result we're reached here is validly characterized as technical, precedent-bound, and unresponsive to policy considerations. But having adopted approach to diversity jurisdiction for unincorporated associations, we're leaving it to Congress to adjust and respond to policy concerns. And I think under the current approach that there is no diversity jurisdiction here, even if you could come up with a compelling policy rationale why Congress might revisit those rules and expand that jurisdiction.
One question I'd like your view on, what's the definition, as you understand it, of additional parties?
As I understand that, first of all, I think the most important part for this case is that it has to be literally an additional party, not just a citizenship of a single party. But I think beyond that, I think to your question, Your Honor, I think the courts have said you really have to have a real dispute between the citizens of the case. It's something a little bit greater than a fraudulent joinder. You've got to have an actual dispute between those domestic citizens, and then you can have additional foreign parties. If the real dispute is between a foreign party and a domestic citizen, and the sort of domestic citizens are the additional parties, then there's no jurisdiction here. That's how I understand courts have approached that. We haven't argued about that here. We really think the problem is a different one.
All right, thank you, Mr. Ellis.
Thank you.
Chief Judge, if I have 5 things I want to tell you, and if I need a little equal time, I hope you'll indulge me, but I should be able to be efficient.
Keep us entertained.
Great. All right. I want to begin with my friend's concession to Judge Wynn's question about what would happen if we were dealing with individuals instead of an entity, and his concession that there would be jurisdiction in that case. That highlights, number one, the absurdity of the defendant's position, which is what they're trying to do is a gotcha. And it also brings me back to the thing that I wanted to say before at the end of my time about Bank of the United States against DeVoe. And I know it's an old case, but there is a passage in that case that is really timely, which is right at pages 87 to 88 of the opinion. Chief Justice Marshall is talking about the purpose of diversity, which we all agree with, and he says that where an entity is not treated as a citizen, you look to the citizenships of the members. So he's establishing the rule that is adhered to in Cardin and Gruppo. This is the case that established that rule. And then he says, substantially and essentially, the parties in such a case where the members of the entity are aliens or citizens of a different state from the opposite party come within the spirit and terms of the jurisdiction conferred by the Constitution on the national tribunals. So this is Chief Justice Marshall linking the purpose with a pass-through entity and saying that in that kind of a case, aliens or citizens of different states work for purposes of the statute. And at that time, there was no A3. So this is about, are there citizens of different states?
Well, you just raised the point. This is a question of statutory interpretation, right?
Right.
Not the Constitution. So Congress could change that.
Right. He's applying the statute. This is a statutory, Bank of the United States against DeVoe is a statutory case. So that's the first thing I wanted to cover. The second thing is I couldn't disagree more with the misdescription of this court's decision in general technology. There absolutely was not a reasoning of we're going to test one citizenship and then we're going to test another. They didn't say that. And if you look at the diagrams of that case in my brief, on pages 20 and 21, you see the reasoning is we look at, and that's what the words of the case say. We line up the citizens on both sides and see if there's a match. That's general technologies. I want to talk about Leland for a minute. My friend misreads Leland. What Judge Jones was saying is, number one, she was rejecting the exact argument that they were making as counterintuitive. And then she went on and said, and I'm going to follow the 11th Circuit. And there were two reasons why she rejected their argument. Well, I agree the 2011 amendment changed the second reason, but the power of the reasoning remains with the first reason. Number four, the other side points out correctly that there have been many amendments to the statute since 1948. And at least, when I went to law school, which admittedly was a long time ago, what I learned was the way Congress changes a statute is by amending the words of the statute. And so you don't say, well, the gestalt of the statute is that it's changed. Congress wants to narrow jurisdiction, and so they've done a bunch of things. You look at the actual words, and if this contamination idea were important enough to be real, Congress would amend the statute in the same way they did with representatives or directed actions.
Follow up on the question I think Judge Qualibon brought up regarding, seems like it was pertaining to between citizens. And the question that I have is, do you agree that TPUK is an additional party, not a central party?
It's an additional party. I don't think that additional party means like an ancillary party. It just means it means another party. It doesn't mean like like optional party. It means additional party, another party. So if I may just address the Rule 41 issue because it came up and there were a lot of questions about it. And I just want to say two things about the Rule 41 issue. The first is the reason that we cited this court's decision in Shuford is because the question that the other side was arguing was that federal Rule 41 displaces the North Carolina savings provision. And this court in Shuford applied the Erie Doctrine, applied Shady Grove or the Shady Grove predecessors. And I know this came up recently in the West Virginia context, similar to Burke against Choi. It's just the precedent in this court, and it is correct, is Rule 41 doesn't displace the North Carolina statute of limitations. And the real question, which I think the court was asking, is why do we have judicial power to see the case on if you're going to send it away, and I don't want you to, obviously, but why do we have judicial power to invoke a state savings provision once we've decided we don't have jurisdiction? And I would submit that there are several other examples where the court sends a case on its way because it doesn't have jurisdiction, and that is perfectly okay. I'm going to give you three examples.
You better do it quickly because you're 2 minutes over.
Example number one, 1369. The court says, I don't have personal jurisdiction over this case, so I'm going to transfer it to another district. Example number two, the district court dismisses for lack of jurisdiction and says, I'm dismissing with prejudice. This court can correct that and say the dismissal needs to be without prejudice. And then the third example, the one that we've been talking about, on appeal, the court says, well, they gave it a good try, but I don't see the jurisdiction. We can fix it. We've concluded there's no jurisdiction, but we can fix it by dropping a party. That's the court, this court's appellate power, inherent appellate power. That happens after there's already no jurisdiction. So if you, and the reason that the court has power to do those things is because they are not merits determinations.
All right, thank you very much.
Thank you.
I want to thank both counsel for their excellent arguments this morning. We'll come down and greet you here shortly. Good. Come down and greet you and move on to our final case.
Thank you. Well done. Thank you, John. Thank you. Appreciate it. Thank you very much. All right, carry the load. Thank you. Thanks, good job. Hey, good to see you. Thanks for being here. Sure did. Good morning, Joe. Good to see you. Thank you for being here.
All right, please be seated. Our third and final case, 25-4531, United States versus Morgan. Ms. Gleason.
If it pleases the court, my name is Kathleen Gleason, and I represent the defendant and appellant in this case, Travis Morgan. The issue in this case is whether the district court erred when she did not vary downward from a correctly calculated guideline sentence, which I understand is a high bar. And I think really at the outset, I don't know if it's a gatekeeper or not, but I think the first thing that I need to address is this court's ability to consider, to presume that a within guideline sentence is reasonable. And in this case, I believe that it is that Mr. Morgan has met that presumption because the purpose of being able to presume a within guideline sentence reasonable is based on the long line of sentences or of cases that have explained sort of the purpose of the guidelines. I mean, the purpose of the guidelines is to have some uniformity. There's a presumption that when the guidelines are correctly calculated, that each of those specific offense characteristics are relevant to a sentence in the case. The cases have called the guidelines, the lodestone or the benchmark, and I think that's correct. In this case, the reason that it is different is because of the way the guidelines were calculated. Mr. Morgan possessed a firearm that had an extended magazine. It had a magazine with a capacity of 16 rounds. The threshold for an extended magazine is 15 rounds. The
difference in this case is that while his guidelines are enhanced for that possession, so a within guidelines sentence essentially punishes him for the possession of what's presumed to be a more dangerous firearm. Where in Mr. Morgan didn't own the firearm, didn't choose the firearm, he had no sort of responsibility or agency of why the firearm in his hand had an extended
Can I
magazine.
ask you about that? Do you concede that the guideline doesn't really get into that level of detail? It just says if you possess a weapon with an extended magazine, you're liable to have this enhancement applied to you?
Yes, Your Honor, it absolutely does. And that's why Mr. Morgan did not contest the calculation of the guidelines. And that's
Aren't you asking us to rewrite the guideline?
No, Your Honor. What I'm asking the court to do is to consider that when the district court entered its sentence, that it abused its discretion by not considering that while the specific offense characteristic applies in calculating the guidelines, to consider the reason why it applies, and then because I've alleged a substantive error, then consider that reason as it affects the 3553A factors when imposing a correct sentence.
So address my concern. It looks to me you can't win on the guidelines argument. So what looks like to me is something you might want to call like a collateral attack on the base offense level here, because that's a different sort of entity. But am I reading that, at least in terms of the way you're going on it? I don't think you can win on the guidelines argument here just in and of itself, because that just doesn't fit. But the base offense level is what you really are attacking here.
Yes, Your Honor, I actually agree with that Mr. Morgan can't attack the calculation of the guideline.
I mean,
Firearm
of it, I'm not sure I've ever seen a case with the facts of this, and maybe it bears at least make sure we're on the same page as what we understand the facts to be. Give us a little factual basis of what happened here, because I'm seeing someone who's in a car that uses the very gun that the guideline says is going to give you a higher sentence.
Yes, Your Honor, I'm happy to do that. What happened in this case, and it's all in the record, of course, is that Mr. Morgan and his girlfriend were having an argument in their residence, and he pushed her down, and she got up and was going to leave. And he said some words, I don't remember them exactly, not nice words and threatening words to her. And
He said something like, "You won't ever get there," something like that.
That's correct. I certainly can't hide from the facts, Your Honor.
Yes.
And she left to get into her car to leave. He grabbed the firearm, which belonged to his girlfriend, and went out.
Get it from?
Your Honor, I frankly don't know. I wasn't trial counsel, and it's not in the record.
He could see the firearm he grabbed.
He certainly knew about the existence of the firearm.
What was that firearm?
It was a 9mm firearm. It was a handgun. I don't remember exactly.
With this large magazine in it.
Well, and I think that's sort of that is an issue, I think, and I'll continue on exactly what happened, but I do want to address that because the idea of a large capacity magazine, the threshold is 15 rounds. This firearm had 16 rounds, and there's nothing in the record from which I think any court could presume that it was obvious to Mr.
He sure knew how to use it. He knew how to use it. He didn't have to fumble with it. He was familiar with that gun.
Yes, Your Honor. But the question of whether he could tell that it was a 16-round magazine versus a 14-round magazine, I think is a question that we can't make a presumption about.
Why does it matter?
Because I think it goes to the culpability, Your Honor. If he knowingly, if the government had proven that he possessed this firearm knowing that it had an extended magazine and selected it for that purpose, then I think I'm in an entirely different posture.
But I mean, I understand why knowingly would make it factually different. It doesn't matter as to whether the guideline itself applies, though, correct?
That is correct, Your Honor.
And didn't the district court consider the circumstances of how your client acquired or got hold of the gun and used it, that it was kind of an opportunity situation. I mean, the court addressed that and considered it. Yeah, I'm kind of, I mean, I can appreciate why a situation would be more egregious had it been the defendant's own gun and clear evidence of awareness intent. But if the guideline doesn't make that a factor and the district court considers it in determining the sentence, I mean, how do we do anything with it at that point when the sentence is within the guidelines?
Well, I think that it's a fine distinction, Your Honor, certainly. The court did discuss that the crime was an opportunistic one. However, the opportunistic part was the possession of the firearm. The court didn't address the nature of the firearm, and I think that's where the distinction I'm trying to make is that he was certainly culpable for possessing the firearm. He's culpable for having a previous crime of violence. He's culpable for his criminal history. So for all those things, he is culpable for. But the nature of the firearm is the thing that was not considered when the judge was considering the 355A factors.
So I want to make sure I understand that. Are you arguing he just didn't give enough indication that he had understood that distinction that you just made? Is that your primary argument, that there wasn't enough explanation, that the district court took into account that?
I think that, Your Honor, the argument is that the court didn't consider weighing the nature of the possession of the extended magazine with the 3553A factors. Things like the need to protect the public, or the dangerousness of the person, or even deterrence. Because the purpose of adding this to the guidelines after the end of the semi-automatic assault rifle ban was very specifically to address prohibited persons having a more dangerous firearm. And so for him to not have any culpability for the fact that there was an extended magazine does lessen the question of whether.
But there's two ways you could look at that. You could say, and I wondered about this, is that, in effect, if there's, the absence of intent in this way you describe it, there's, a duty not to apply the guidelines. And at times it seemed like you were arguing that. But then there's another way you could argue it, which is, okay, the district court needed to, if he was going to apply it, give more of an explanation. First being kind of almost a legal duty, the second being a failure to explain it. Are you saying the latter? Are you saying the former? Can you tell me what the nature of the argument is?
Yes, Your Honor. And the district court, when it imposed its sentence, didn't consider a downward variance at all. In fact, the district court said, I'm considering something at the high end. The court didn't address the nature of his possession of the magazine at all when the court imposed the sentence.
Well, I mean, let me ask you about that, because I don't know that that's fair. With Judge Eagles is a pretty experienced judge, and she didn't maybe use the precise words that you're now suggesting she should have, but she did say, first of all, she, and I'm just paraphrasing part of what she said, the nature and circumstances are aggravated. He chooses to get a gun. And then she says this, it may well have been a crime of opportunity, as his counsel says, but he had to get the gun. So she's acknowledging that the gun just happened to be there. Your client grabbed it and it went south from there. I mean, why isn't that enough? I mean, she's acknowledging that he didn't intend to start out by grabbing a high magazine weapon. It was just there and he used it. But in her mind, she didn't focus on the fact that he had to pick the gun up, he had to take it outside, he had to shoot it, and that's intentional, and it's so dangerous. That seems pretty nuanced to me.
And Your Honor, she did essentially cover most of the bases in the when she pronounced her sentence. And I think that My argument is that when she discusses the opportunistic nature of it, that it's the possession of the firearm itself, and that she doesn't address the fact that his guidelines were increased for the possession of what's considered a more dangerous weapon when there's nothing in the record that we know that he even knew that it had 16 round versus a 14 round.
That's a fairly, we have some variety in our cases about what district courts must explain and must not explain, but that would be an extraordinary level of detail, wouldn't it, that a district court must give, not just to say what Chief Judge Diaz mentioned, that this is a crime of opportunity, acknowledging that fact, but say, well, you must not only say that, but you must then go further and say, well, let me consider whether his, had sufficient intent, when the guideline doesn't even call for intent. It just seems like we're putting a lot of, constraints on district courts if we require that level of detail.
And Your Honor, I don't disagree with that. And it's a very thin line on the question of procedural versus substantive error. And I'm not claiming that Judge Eagles committed any procedural error, that she didn't say the right magic words. She certainly said enough to indicate that she considered issues of mitigation. It's really that then when applying sort of the facts of the case to the 3553A factors, that she did err by not doing that at all, as far as the fact that his guidelines were increased by 2 levels for something that it's sort of a strict liability issue. So the guideline was correctly calculated, but to also consider his culpability and then use that to consider the 55.3 consider the sentencing factors, Your Honors, and then vary downward because he really had no culpability for that 2-level increase. The court has no other questions. I see my room.
Thank you, Ms. Gleason. You've got some time for rebuttal. Morning, Ms. Niemeyer.
Thank you, Your Honor. May it please the court. Julie Niemeyer for the United States. As I think the court has recognized, this isn't a terribly difficult case on these facts. This is essentially a case about the standard of review. We know the standard is reasonableness. We know what that means. We look at the procedural reasonableness. We look at the substantive reasonableness. But why? Why are we asking that question in this particular case for a guidelines sentence?
Well, it's not challenging procedural reasonableness. This is a substantive reasonableness.
Absolutely, Your Honor.
And the question I would have you is, are there any circumstances that you think of which a district court might be required to impose a downward variance?
Absolutely required? No, I wouldn't commit to that, Your Honor. No, I think the decision to vary is one that is at the heart of the district court's discretion, and it's bound up in those procedural requirements. The court has to listen to the request for a variance. The court has to carefully consider the arguments for a variance, consider the record, evaluate that request in light of the 3553A factors. But ultimately, it's the court's decision to decide whether a variance, either upward or downward, is justified. And it really goes all the way back to the Sentencing Reform Act. My friend talked about the historical nature of this inquiry, and that's just so important because under the Act, the guidelines were mandatory. And the Sentencing Commission was carrying out a very detailed, very complex mandate from Congress at Section 9.
Level increase require mens rea?
I'm sorry, Your Honor, can you restate that?
Does base level increase require showing mens rea?
It does not, Your Honor, unless
What's being argued here?
it does
The
not. Your Honor.
guidelines challenge is really dealing with the base level offense. And the question with her perspective is that, well, he didn't know this gun was one that was over 15. Do we look then? I called it something looked like a collateral attack to me, but I won't use that term in describing it otherwise. But the question really is mens rea required in determining whether to impose a base level increase?
Your Honor, we know that the guidelines tell us when mens rea is required in the base offense level calculation. If the guidelines don't mention a scienter requirement, there is none. And the Sixth Circuit in the Sewell case had occasion to look at that very question. Even though this court has not, to my knowledge, yet addressed it, that case is very persuasive because it points out that the guidelines absolutely know how to make it clear when there is a scienter requirement, if they want one to be considered by the district court. And the amendment that actually created the language at issue here for the large capacity magazine enhancement included another provision, another amendment that added a scienter requirement in it, and it had to do with the trafficking enhancement. So the commission clearly knew exactly how to impose that requirement if they wanted to do so. And here they did not. And I'd also like to point out that that base level enhancement wasn't a new enhancement. The amendment merely rephrased the verbiage because it had been linked to the definition of an assault weapon at 921A30. And when that provision was repealed, we could no longer refer back to the language of that statute to know what brought about the enhancement. And so we had to lay it out in actual definitional text. So that's why we see the current phrasing used in the guidelines.
You just, I thought I heard you say earlier that the district court certainly considered all of the relevant factors, and indeed that's what's required in order to satisfy procedural reasonableness. You know, there's some logical force, I think, to the argument that Mr. Morgan made below that, well, you know, I didn't go out and purchase a weapon with a high capacity magazine. It just happened to be there. I grabbed it and started firing. And that is a distinction, I think, that is significant. And I think a district court would err if it simply ignored that as a procedural matter. Do you disagree?
I don't, Your Honor. Absolutely.
But your point is that the court considered that and said, it doesn't matter. Well, first it said, I acknowledge your argument, but here is why I think it doesn't matter in this context and why I think the sentence that I'm about to impose is appropriate. And then she laid out all the reasons Judge Eagles did why she thought the sentence was appropriate. And I guess from your point of view, that is essentially a bulletproof sentence.
I wouldn't say bulletproof, but in this
That may be a
case,
bad analogy.
very well justified.
Context, yeah.
Because it all goes back, Your Honor, to the Rita case, essentially, and its discussion of why we can give a presumption of reasonableness to a guideline sentence. It's not only because the court abided by the requirements of procedure, it's because that guideline range wasn't created in a vacuum. It was created by the commission after evaluating actual data. 10,000 plus cases and their outcomes were analyzed. The mandate of Congress was considered and carefully incorporated into the guidelines. And so when the outcome of that quantification of the harm of a particular offense, coupled with the background of a particular offender, when that results in a certain range, and then in a parallel fashion, the district court judge is applying the 3553A factors and carefully analyzing the record in that light, if the court then arrives at the decision that the guidelines range remains appropriate here, and the Sentencing Commission made that same conclusion, there's a coherence created by that. That makes the sentence presumptively reasonable? Because it's not a binding presumption. Of course, there could be the odd case where the court still arrives at a sentence that's too high, but it's presumed reasonable because that's how Congress originally defined reasonable. It was the Sentencing Reform Act, the guidelines. If the guidelines were appropriately followed, that was a legal sentence. And so after Booker, the courts had to devise a way to quantify that process of analyzing reasonableness. And it chose this presumption for the appellate courts because of the process that had already been followed by both the commission and the sentencing court. When they came together, that just created a strong presumption that that sentence was legal and that it was reasonable. And another thing just to mention briefly is that this presumption is only an appellate presumption. The district court judge can't look at that PSR and say, oh, here's the guideline range. Nobody is saying that there's an error in the guideline range. And so I'm going to just stick with this range unless somebody tells me otherwise. No, the court still has to conduct an independent analysis, an individualized assessment of this defendant's conduct to see if that range is appropriate in that particular case. So there is no presumption at the district court level, as this court recognized in, I believe, the Mendoza case. And it's very important that we follow that principle. The district court has to do the analysis from scratch, consulting the guidelines, consulting the 3553A factors, listening carefully to the arguments of the defendant, but then ultimately reaching his or her own conclusion about what is sufficient but not greater than necessary. Just addressing very briefly the actual enhancement here. Just a couple other minor points about that enhancement. The harm represented by the enhancement is present whether or not the defendant had any intent regarding that particular magazine or weapon. The Sentencing Commission was asked to evaluate harms because it was trying to make the sentences across the nation more uniform. Instead of this judge sentencing this person to 3 years and this judge sentencing that person to 8 years for the exact same 922G1 offense. We want it to be more uniform. That's what Congress intended. And so when it devised this particular enhancement, it was recognizing the particular harm of that large capacity magazine, or as previously defined, that assault weapon with particular characteristics, the particular harm that presented.
Can I ask you about that? Ms. Gleason makes an argument that her client had no way of knowing just how many rounds could be fitted into that magazine, or even what the number of, how big of a capacity the magazine actually was, because it, as from their point of view, he just picked it up without even considering that. I'm not sure that that particular argument was made to the district court. And I mean, tell me if I'm wrong about that.
Actually, Your Honor, it was. If you would look to JA 60, you'll see where Mr. Morgan's trial defense counsel did say, in most cases, the reason that enhancement is applied is the reason for a more severe sentence is because it represents a statement when a person who is already deemed to be a danger to society, a convicted felon, arms himself and then takes the extra step of increasing the destructive capacity of the weapon with a high capacity magazine. Court then replies, I see what you are saying. All right, thank you. So we hear the court specifically listening to counsel on that argument and engaging with counsel. Back to the substantive reasonableness issue here. We have to look at the fact that the court had the discretion to vary but it chose not to exercise it. And in that sense, a guideline sentence is almost even more reasonable than pre-Booker than it would be when it was mandatory, because then the court had to remain in the guideline range unless there was a specific reason to depart.
In
And that
fact,
had to
the
be,
court, went down a bit from the top of the guidelines range, right?
absolutely, Your Honor. Yes, the top of the range was 115 months. And the court, giving careful consideration to those arguments in mitigation, such as the fact that Morgan contacted law enforcement and told them where the gun could be found to prevent it from being inadvertently found by children, and some of his other arguments, including this crime of opportunity argument, came down to 110 months, despite commenting that this was perhaps one of the most dangerous and serious examples of a 922 G1 offense, a case where someone not only possesses a weapon, but shoots it. The court said it's not necessarily just what you intend, but it's what you ultimately do with the weapon. And that's what I find very important in this case. The court said, when you fire a weapon, you create just an extremely dangerous situation. Even in a situation where a defendant perhaps didn't intend to cause immediate physical harm to the girlfriend, but it could have gone off course, could have, misfired, could have had bad aim. We don't know. Anytime you're discharging a weapon, it's just an extremely serious and aggravated situation. But despite that, the court still came down to 110 months rather than 115. In closing, I'd like to just invite the court to recall the Fowler case, where this court recognized that sentencing is a dialogue between the trial judge and the appellate court judge. And it's a dialogue where the trial court judge has an institutional advantage. And it's for this court to respect that institutional advantage in the appropriate cases, to defer to the court below. Thank you.
Thank you very much.
Think, sort of sitting there thinking about sort of what is the heart of the argument that I'm making. And it is that there are sort of two issues here. There's, were the guidelines calculated correctly? And then the separate question that seems to be confounded, but I think it's a separate question of whether the guidelines are appropriate in this particular case. The guidelines were calculated correctly. It is essentially a strict liability issue of the nature of the magazine and the firearm he possessed. The issue that the district court did not consider when considering the appropriateness of the sentence against those sentencing factors is whether the guidelines are appropriate in this case. It's kind of a rare case, I think, Your Honors, where a defendant agrees that the guidelines are correctly calculated, but that those calculations don't actually appropriately account for the lack of culpability. I mean, he earned the 4-level enhancement for possessing a firearm in connection with another felony offense.
Can I ask you a question? So what, if we were to agree with you, what would we tell the district court to do?
I think what the district court should have done and abused its discretion when it did not do was exactly that, to consider the appropriateness of the guideline calculation, not just whether the math is correct, but whether looking at this person and these circumstances, whether this enhancement is something that does make a difference when considering the sentencing factors for things like dangerousness.
And you don't think that bearing down from the top of the guidelines range does the trick?
I don't, Your Honor. She addressed the other issues in mitigation. She did not address the appropriateness of the guideline calculation.
Is it your view that if Judge Eagles had done exactly what you just said she should have done, she could not arrive at the sentence that she arrived at?
Your Honor, she could have arrived at that same sentence. And that's we're asking to vacate the sentence to have the court make sure that she considers the appropriateness of the guidelines, not to for a resentencing. I think it's, as long as the court supports its sentence, certainly, especially within a guideline sentence, or that would not be reversed. And
I consider Judge Eagles to be a very patient and thorough judge, but I think she might be steaming mad if she saw this case again.
I would step very slowly, Your Honor, when I entered that courtroom.
So you wouldn't see it for long.
She would resentence him,
Give
and
the same sentence without even considering this.
it's entirely possible, Your Honor. And this just happens to be a case where there isn't the presumption of harmlessness because she didn't make that pronouncement.
You know, one point you're making is the Sentencing Commission has a unique role, and over the years, in terms of how we view the guidelines, a commentary to it is a subject. But in terms of the kind of argument you're making is one of the reasons it chooses to have large magazines to be an enhancement as opposed to lower ones. And it seems that the considerations you're bringing to bear would be part of what the Sentencing Commission would deal with. And if we go down this road, where does it go with other things that the Sentencing Commission do? Do we second guess as to what the policy behind this and that, when there's, you know, over the years, it's the very purpose of the Sentencing Commission?
Well, Your Honor, I'm not arguing that the guidelines themselves should be changed. There are some other things, for instance, in the firearm guidelines, the possession of a stolen firearm is another sort of strict liability case. If the firearm was stolen before the person was born, then that's something that the court would consider when considering a variant sentence. So I don't think that it's something that rises to the level of the Sentencing Commission needs to make sure that the judges are doing these kind of analyses. I think, frankly, that's the job of defense counsel, Your Honor, to make sure that these things are brought before the district court, and in this case, it.
All right, thank you very much.
Thank you.
I want to thank both counsel for their fine arguments this morning, still morning. We'll come down and greet you. Then we're going to go back and conference these cases. And then after we're done with that, we'll come back into the courtroom and Dean will be happy to answer questions. All the hard questions go to my colleagues. I get these. All right. We'll adjourn court.
The honorable court stands adjourned, sine die. God save the United States and all.
Thanks for being here.
No, that's right. That's right. Yeah. Oh, well, thank you, Your Honor.
Yeah. Thank you. Appreciate your help with this case.
Appreciate
Good to see you again.
Good to see you as well.
Thank you, counsel. Appreciate your work.
See you. Nice.
Many of you students really need to go to the bathroom. Run and do it real quickly, because we don't want to be going in and out during the Q&A. Okay. Everybody did so well this morning. Thank you for coming to the school and education. So you.
I am. Little brother fired me back in 2019. Those